Hello everyone, this is Debujit Das to welcome you back to another episode of Courts Today by LiveLaw, and today was a pretty happening day across the courts of our country. From Narendra Modi's BA degree to BROCODE, we have a lot to catch up on. So let's begin. For our first story, the Supreme Court Bar Association has filed a writ petition in the Supreme Court of India over deeply troubling reports from Maharshi Dayanand University in Haryana, where female sanitation workers were allegedly subjected to invasive period checks, even being asked to send photographs of their sanitary pads to prove they were menstruating so they could work. The petition argues that these acts are a gross violation of the women's right to health, dignity, bodily autonomy, and privacy under Article 21 of the Constitution. It isn't treating menstruation like a private health matter. It's turning it into a tool for workplace humiliation. The Supreme Court Bar Association has asked the Supreme Court to issue binding guidelines similar to the landmark Vishakha versus State of Rajasthan norms, so that no woman or girl can ever be exposed to such degrading treatment in educational institutions or workplace again. In short, this petition shines a harsh spotlight on institutions that treat menstruation like a problem to be policed rather than a natural biological process, and demands the law to step in to protect dignity, not demolish it. Next, the Delhi High Court today sharply questioned Narendra Modi's long-running degree controversy, demanding responses from Delhi University over its delay in filing appeals related to the BA 1978 results, the year the Prime Minister of our country purportedly graduated. The bench, comprising Chief Justice Devendra Upadhyay and Justice Tushar Rao Gedela, instructed Delhi University to file objections within 3 weeks concerning this delay under RTI-related proceedings. The case traces back to RTI applications by activists including Neeraj Kumar and Sanjay Singh, seeking marksheet details of all the students who appeared in the 1978 BA program. Delhi University in its appeal argued that these records were personal information and exempt from disclosure under the RTI Act, a stance the court now appears restless about. Appearing for Delhi University, Solicitor General Tushar Mehta admitted the appeal was delayed and said a reply would be filed. The court, however, withheld formal notices, signaling clear frustration with what it perceives as government foot-dragging on a matter of public interest. For our third story today, we saw the Supreme Court stepping in on what it called a clear case of police overreach by the Haryana Police, ordering the immediate release of Advocate Vikram Singh, arrested in a murder case that, according to him, was nothing more than a coercive ploy to force him to reveal client information. A bench led by Chief Justice B.R. Gawai directed Singh's release on a 10,000 rupees bond and instructed the police to immediately inform the Gurgaon Commissioner. The court stressed that a practicing lawyer with no flight risk whatsoever should never have been put behind bars in this manner. Singh's petition described a disturbing scenario. He had received a notice under Section 41A of the Criminal Procedure Code, which only requires a person's appearance before the police, and he complied in good faith. Yet, instead of recording his statement, officers arrested him without any written consideration or justification of procedural transparency. What makes the arrest even more indefensible is that every other accused in the same case is already out on bail. This episode, the court hinted, reflects a worrying trend of law enforcement using lawyers as easy targets in the name of investigation. It also comes down alarmingly soon after the Supreme Court's own ruling meant to safeguard advocates from being coercively summoned or harassed by police authorities. The next story is related to Advocate Rakesh Kishore, who attempted to throw a shoe at Chief Justice Gawai inside the Supreme Court of India on October 6th, shouting slogans about Sanatan Dharma while the court proceedings were underway. The incident sparked widespread shock. Senior legal bodies condemned it. The Bar Council of India suspended Kishore, and the Supreme Court Bar Association filed a petition seeking criminal contempt proceedings. On hearing the case, the bench of Justices Suryakant and Joy Malia Bagchi flagged two critical questions. Can contempt proceed when the Chief Justice of India himself has chosen to pardon the act? And whether a bench other than the one presided over by the offended judge can initiate such proceedings. The court also expressed interest in framing guidelines for court security and social media norms, particularly to prevent glorification of such acts and to regulate posts that spread the incident. And next story is as existential as it can get, as the Supreme Court of India has again examined the issue of worsening air quality in the Delhi NCR region, but has adjourned the matter until 17th November 2025. During the hearing, the bench of Chief Justice B.R. Gawai and Justice K. Vinod Chandran raised serious concerns about the contribution of stubble burning in neighboring states to the smog crisis. Accordingly, it ordered the states of Punjab and Haryana to file detailed status reports on the steps they have taken to curb crop residue burning ahead of the next hearing. Counsel appearing stressed that the air quality index in several areas had already crossed 450 and yet construction activities were still ongoing, even near the Supreme Court premises. Meanwhile, concerns were voiced over data integrity. One amicus highlighted credible allegations that farmers are timing their stubble burning to play around satellite overpasses, thus artificially lowering recorded numbers of farm fires. Next, we'll take a look at the ORS case and what's happening in the Delhi High Court. The court rejected a request for interim relief from manufacturers of drinks labeled as ORSL or similar, which seem to mimic genuine oral rehydration solutions. The judges held that while these beverages may appear harmless, their resemblance to medical ORS could pose serious health risks, especially for children or people who really need medically approved solutions. The plaintiffs argued that they were not making medical ORS but were just using a brand styling that sounds like it. The court was not convinced, pointing out that the product's appearance and labeling could mislead consumers into believing that they're getting genuine ORS when they are not. Moving on to our next story, where the Karnataka State Bar Council just received a word from the Karnataka High Court. An advocate enrolled in October 2024 challenged the Bar Council because beyond the statutory fee of 750 rupees under the Advocates Act of 1961, the council collected an extra 6,800 rupees labeled optional fees for things like ID cards, certificates, training and welfare funds, referring to the recent top court judgment which capped enrollment fees and barred optional add-ons. The High Court ordered the Bar Council to refund the excess amount and made it clear: no more fee collection contrary to the law. And for a final story of the evening, we move back to the Delhi High Court, which refused to stay the single judge order that had restrained production house Ravi Mohan Studios Pvt Ltd from using the title BROCODE for their upcoming film. The dispute? Beverage company Indospirit Beverages Pvt Ltd, maker of the drink BROCODE, sued the studio alleging trademark infringement and consumer confusion. On appeal, a division bench of Justices C. Harishankar and Om Prakash Shukla observed that granting a stay would virtually amount to allowing the appeal and may even amount to disposing of the suit itself. The court also raised doubts about whether the interim injunction satisfied the legal requirements under Section 29 of the Trademarks Act 1999, which defines when a registered trademark is infringed. It questioned the beverage company how its case meets the key tests of reputation, similarity, unfair advantage, or even detriment. In short, while the filmmakers can continue production, they're barred from promoting the film under the title BROCODE for now, and the trademark dispute heads to hearing in December. That brings this episode of Courts Today to a close, but if you're looking for a detailed coverage of all these stories and more, visit www.livelaw.in and keep following us on all our socials to stay updated with everything that is law. I'm Debojit Das. Thank you for watching.